Welcome everyone to our webinar on essential legal compliance for businesses. My name is Tayler and I'm an associate in the commercial contracts team. I'm joined by my co-host Stephen, who is a practice leader in the commercial contracts team. Before we begin, a couple of quick housekeeping items. So once the webinar is done, you'll receive the recording and the slides in your email. Throughout the webinar, feel free to submit your questions in the Q&A box and we'll aim to answer them at the end. And then after the webinar, please complete the feedback survey, as that's super helpful. Another exciting thing to note, for the next 48 hours, you are eligible for a free consultation with LegalVision to discuss how we can help your business. To claim this, please provide your contact details in the survey at the end of the webinar. So today we will be discussing corporate structuring, consumer law, employment regulations, data and privacy laws, and then we'll have some time for some Q&A at the end. I'll now pass over to Stephen to talk about corporate structuring.
Thanks, Taylor. Legal compliance begins with choosing the right business structure, and this is really important depending on, maybe your goals as a business, the way in which you intend to expand as a business, and even sometimes what industry or sector that you're operating in. There are sort of four main options that we see commonly in New Zealand that businesses sort of structure as. I'll run through each one in turn. Each structure has sort of their own unique benefits and also kind of, downsides in terms of the way that they might run from an operational standpoint. They might be more complicated. Maybe there's a difference in the way in which risk is allocated to, say, the directors or the operators of the business. So it's really important to understand, what your goals are as a business, what the risk profile of your business is, and what sort of industry that what's common in maybe your industry in terms of structuring, because it's not sort of always, an easy answer sometimes, and it can also be driven by other factors such as, tax advice or even just legal requirements set out in relevant legislation. So to start with, we'll start with the most sort of simple structure. A sole trader, that's essentially you in your personal capacity running your own business. It's quite common to see in, say, maybe a startup sense or a small business where, you might have your primary source of employment, primary source of income, and you're sort of venturing into maybe a side hustle or a new sort of venture where you're actually providing those services yourself. Say, consulting is a common one, or any sort of advisory work where you think, I'm doing this sort of, on top of my existing employment obligations or my existing day-to-day. I don't want to go to the effort of setting up a large structure or a new company and incurring those sort of compliance costs. And I also think that what I'm dealing with is low enough risk that I can just get to work and deal with that in my own sort of capacity in my own tax return. So they're obviously very simple and cheap to set up because there isn't really anything to do apart from, if you exceed, I think it's got the off the top of my head, but there's a certain revenue threshold where you might need to register for GST, or if you want to voluntary register for GST. But otherwise, if you're delivering those services, you can just get to work, set up your contract, set up your billing, and you're good to go. The key downside with being a sole trader is that personal liability. So there's no shielding from, any business debts or any business obligations. So if you enter into a contract with a customer or your employees and there's an issue, a breach or a default on your end, you're going to be personally liable, and that does put your personal assets at risk. Sometimes you'll see sole traders who then will take steps to maybe put their personal assets in a different sort of holding vehicle to kind of mitigate that where possible. But that's obviously when you sort of get into that point, you might be looking at maybe how you can structure your business in one of these other models to kind of mitigate that anyway. The next structure that we often see is a partnership. It's probably less common than, say, a sole trader or a company or a trust, the other ones that I'll touch on soon. They are more common in professional services. So you'll see partnerships come up a lot in law firms, sometimes in, other professional services, accounting, consultancies, things like that. They can be, they kind of come up a lot when you've got a bunch of maybe founders or key leaders or partners in the business who are willing to share ownership, control, but also profits and losses and risk. And usually they're bound together for, and sometimes through a partnership agreement that'll set out the rights and responsibilities of each partner in the arrangement. And there are two sort of main types. It's a general partnership, so that's where partners, will manage the business and are personally liable for debts. The one thing to keep in mind too is, and the reason why we'll see a lot of clients set up companies is there might be them and a co-founder who decide to start a business together. They both can't be a single sole trader. So the only sort of default legal position is that they might actually be inadvertently a partnership. And so either they'll get an agreement drafted up to kind of deal with that arrangement, or they'll set up a company and be shareholders to kind of avoid the complexities of and the risk that comes with being a partner, because you are oftentimes, unless your agreement deals with it otherwise, jointly and severally liable, which means if your partner does something, you could be responsible for that. So it's not one that is as common in, say, other services, apart from what I've mentioned previously around law firms and professional services, but they do pop up elsewhere from time to time. We're actually seeing less trusts recently. So a trust is essentially a legal arrangement where these trustees, usually individuals, they can be companies, have this responsibility to manage property on behalf of others. They're called the beneficiaries. They're very common in a family setting or personal settings to see a family trust where it might own the home for the benefit of, kids or anything like that. And so, the trustees are responsible for managing the trust and usually in accordance with a written trust deed. And that sets out the powers of the trust and what the trust is set up for. Now, I do have a number of clients that use a trust vehicle for investing, maybe as a vehicle for holding other companies or holding their own shares for personal, so sort of asset protection and things like that. So that's also quite common. I guess the downside is that they're very complicated sometimes to operate in that business setting due to the number of formalities that are required. So, the trustees have to be involved in all the decision making. If it's a, more, I guess, a family investment sort of trust, you've got to really distinguish between the trust as its own kind of legal persona and that of the family member or the individual. It's not sort of a piggy bank that an individual can dip into whenever they like. Once money's been put in that trust, it no longer belongs to that individual. So there's sometimes a blurred line, and we see clients who don't understand that actually once they've given that money away, it's in the control of the trustees, and there's a process that needs to be followed when it comes to approving an investment or approving a payment around regular meetings, resolutions, things like that. So they can be good for personal asset protection. They can be more complicated from a business standpoint, which I guess leads us to the most, I guess, popular form of entity set up for a business, which is a company. I'm sure many of you on this call either work for a company or have one yourself. The benefit of a company is obviously its limited liability. So, there's a degree of separation between the people who are, maybe are responsible for the business, say the directors and the owners of the business, or the shareholders, and then the actual risks that the company takes on, because the company is essentially given what we call legal personality. It kind of exists as if it were a human being, but obviously it can't think and feel for itself, and it needs directors to guide it, and it needs employees to kind of carry out its functions. So there is a bit more compliance, obviously, in terms of, director meetings, shareholder meetings, things like that, annual return fees. But overall, on balance, I guess the compliance burden is kind of the price to pay for that separation of liability and having the company take on, employment risk, customer risk, things like that. In terms of, I guess, sort of the reasons as well that someone would set up a company is around expansion plans and things like that. So having a company means that you have shares. You can sell shares to raise capital. You can also obviously then easily set up subsidiary companies underneath your company to maybe go into other markets or to separate out your risk. So it's quite common to see a structure where you might have a holding company, for example, that just holds really the ultimate owners, shareholders, and might hold the IP. And then underneath it might have a subsidiary for its different business lines. So, you might have a subsidiary for your manufacturing business, a subsidiary for your consulting business, and then a subsidiary for, your professional services, or maybe just for your employment, for your employees to kind of ring fence your liability in that way. And so you can get a bit more creative with your structures when you are dealing with companies. Obviously, with a sole trader, there's just one person. Partnerships are obviously a bit more limited, and trust, as I mentioned, you can have a subsidiary network underneath the trust, but kind of moving money through the trust is a bit more burdensome in terms of compliance obligations. But yeah, that's why the companies, I guess, are the more popular structure for that flexibility and for that kind of future growth opportunity. But that's enough about me on structures, and I'll pass to Tayler now on consumer law, which is obviously kind of a thing that regardless of your structure, if you're in business, it's going to apply to you and impact the way in which you carry out your operations. So thank you, Tayler. I'll pass to you.
Thanks, Stephen. So as Stephen said, regardless of your corporate structure, it's very likely that you'll be engaging with consumers in some way, shape or form. So consumers are individuals who are purchasing goods or services from you for personal use. All New Zealand consumers are protected by two key pieces of legislation. That's the Consumer Guarantees Act and the Fair Trading Act. These laws prohibit misleading and deceptive conduct in trade and set out automatic guarantees for goods and services which act to protect consumers. So when talking about the Consumer Guarantees Act, if you are selling goods, there are guarantees that require that your goods are of acceptable quality. So this means that your goods must be free from minor defects and must be safe and durable. This will take into consideration factors such as the type of the good and the price of the good. So for example, if you were to purchase a couch for $10,000, you would be justified to expect that the quality and condition of the couch would be better than a $500 secondhand couch. Your goods must also be fit for purpose. So this means that the product that you sell must do what you say it will do. For example, if you tell a customer that a watch is waterproof and functions when submerged fully in water, it must do this, otherwise you'll be in breach of that guarantee. Your goods must also match the description given. So this means that any claims you make about your product on your website or in your marketing materials or when kind of communicating with your customers must be accurate. For example, if you claim that a smartphone has an all-day battery life, but in normal use it requires recharging after a few hours, this would mean the product does not match the description given. You must also ensure that your products match any samples or demonstrations that you provide. For example, if a company provides fabric swatches for custom furniture, the actual furniture should match the color, texture, and quality of the swatch that's selected. For services, there are also guarantees, and these guarantees include that your services are provided with reasonable care and skill. Now, that'll obviously differ based on the service that you're providing and the industry that you're in, but you're essentially required to provide services in accordance with the way a reasonable service provider would provide the same services in the same circumstances. For example, you may go to a new hairdresser and have an allergic reaction to the hair dye. If it is determined that a reasonable hairdresser would have performed a patch test before applying the hair dye, your hairdresser would be in breach of that guarantee. Your services must also be fit for purpose. So for example, if you're a caterer and you agree to accommodate to dietary requirements, you must actually be able to do that. Your services must also be completed within a reasonable time and provided at a reasonable price, if not set out in advance. If these guarantees are not met, consumers have the right to seek repairs, replacements, or refunds. It's important to note that you cannot contract out of those consumer laws when selling your goods or services to consumers. However, you are able to contract out of elements of these laws by written agreement when selling your goods or services to other businesses in trade. In order to ensure ongoing compliance with your consumer law obligations, it's best to have clear processes in place for returns, refunds, and remedies. Now moving on to the Fair Trading Act. The Fair Trading Act makes it illegal for businesses who provide goods or services to consumers to engage in misleading or deceptive conduct or unfair trade practices. This means any representations about your business or your services that you make in your promotional material, on your website, social media, or to your clients must be true and correct. Any claims you make about your business or your services must also be supported by evidence. Breaching these laws can result in significant penalties. Under the Fair Trading Act, companies can face fines up to $600,000 per offence and individuals up to $200,000 per offence. So moving on to advertising practices, when advertising your goods or services, as stated before, you must be able to prove any claim that you make. There's a particular focus by regulators on ensuring the country of origin and sustainability claims are true and accurate. So when considering country of origin claims are an important way of telling consumers where your product comes from. Stating the country of origin is often required as part of packaging and labeling laws. You must not say that your product is made in a country, such as New Zealand, if it is predominantly made elsewhere. For example, in 2015, the Real Juice Company received a fine due to misleading claims on their apple juice products. They had said the juice was made in Australia, however, the apples were not grown in Australia, and the juice was made from reconstituted apple juice imported from China. Moving on to sustainability. Equally, when it comes to sustainability, any claims you make must be true and accurate in order to avoid being seen as greenwashing. For example, Z Energy, a New Zealand petrol company, is facing a complaint which is currently being evaluated by the Select Committee as a result of their slogan, "We're in the business of getting out of the petrol business," and making other claims about reducing their carbon emissions, despite their carbon emissions increasing at the time. Another example coming from Australia, Clorox advertised that its Glad kitchen tidy bags and garbage bags were made of 50% plastic collected from the ocean or sea. However, the Australian Competition and Consumer Commission found that the plastic was collected from communities in Indonesia up to 50 kilometres from a shoreline. So just be careful about the claims that you're making. In terms of sales promotions, to attract customers, you may be considering some sort of promotional scheme. So sale promotion schemes are popular marketing strategies used by businesses to boost sales, attract customers, and just increase brand visibility. Sales promotions involve a business offering consumers the ability to enter a draw to win a prize as a result of purchasing a product or service from them. It's important to note that sales promotion schemes are a form of gambling under New Zealand law and are therefore highly regulated. To be compliant with the law, a sales promotion must meet a number of criteria, including the fact that the purchase price of the goods or services must not exceed their usual retail price, so the price that you usually sell them for. A participant only needs to purchase the promoted goods or services to enter and cannot pay any sort of entry fee. And the outcome of the sales promotion must be determined randomly by chance. The actual prize of the sales promotion is also relevant. For example, you cannot give away items such as tobacco, alcohol, or firearms. The penalties for failing to comply with regulations for sales promotions are significant. Where you fail to comply, you may be found to be conducting illegal gambling. Companies can receive a fine of up to $50,000 and individuals up to $20,000. Moving on to online reviews. It is against the law for a business to create fake or misleading reviews or to arrange for others to do so. You must only collect genuine reviews from actual customers, and you must not edit or alter reviews. You also cannot exclude customer reviews, such as those from unhappy customers or those that are negative. If you provide a customer with a benefit for leaving a review, such as a discount code or loyalty points or some other reward, this must also be clearly disclosed. I'll now pass over to Stephen to chat about employment regulations.
Thanks, Taylor. So moving on to employment. So every employee must have a written employment agreement is the key starting point. And in that employment agreement, there should be a number of things set out, which we've obviously listed out here. The first one, and probably the most important to get right, is what the nature of the employment is. And I'll touch on contractors on the next slide. But what is the type of engagement for this employee? Are they a permanent employee? Are they part-time? Are they fixed term? Or are they casual? Now, for those last two, fixed term and casual, there are specific requirements. You know, a fixed term contract, for example, there must be a legitimate need for that fixed term role. A fixed term can't be used as a trial period or as a way to kind of limit the way in which someone engages with your business. There has to be an actual reason or rationale for it. Common ones we see are things like summer internships. You might have a university student. They obviously have university until the end of the year, and then they have to go back sort of, maybe February the following year. And so they have that, only that period of maybe 3 months in which they can actually work. And that's kind of a justified reason. Seasonal work is a common one, sort of in fruit picking, orchards, things like that. And also for things like, maybe short-term projects where, or maternity leave cover, where that there's kind of a defined need that can be kind of backed up and proven. And then casual contracts as well, it's just important to make sure, if you're dealing with a casual employee or bringing someone on a casual basis, that it actually is casual, that there's not sort of a pattern of work that is actually more part-time or permanent employment, because that can have an impact on, I guess, the rights and responsibilities of you as an employer. Your contract as well should obviously set out things like hours of work, how much they're getting paid, how that works in terms of KiwiSaver contributions and things like that, leave entitlements, and obviously termination procedures as well. It's also important too that if you're, I guess, relying on the 90-day trials, so those are now available again for all businesses, not just small businesses, that you're only using them with employees that you're employing for the first time, so you can't have someone on a casual contract then move them onto a permanent employment agreement with a 90-day trial, or a fixed term to a permanent with a 90-day trial. So it has to be the genuine first time that they're an employee of your business. And you obviously have to make sure that, the fact that there's a trial is disclosed and following the procedures there correctly. You've obviously got then things like your minimum wage compliance is pretty standard. So minimum wage at the moment is $23.15 per hour. That's obviously reviewed annually. So making sure that you're across the latest, I guess, minimum rates there. And then just making sure that you understand the minimum holiday entitlements and how those work. So obviously there's 4 weeks annual leave, public holidays, and sick days. There's also, I guess, changes that have happened around leave for, there might be bereavement, family violence, things like that, making sure you understand what the latest position is, because obviously, employment is ever changing. Every time there's a new change in government, there's obviously a change in policy, and that can have an impact as well, as we've seen from the change in 90-day trials, for example, and a change to contractors that's been flagged, which I'll touch on shortly. Another key obligation for employers is obviously health and safety. So if you, I guess, are a business or an organization, you have responsibilities, especially as directors of that business, or if you're in a senior sort of management role, you're an officer of that business, so to speak, you have a responsibility to identify and manage risks, to provide safety equipment and training, and to have appropriate emergency procedures. So it's not a responsibility that you can say, oh, just because no one's ever been hurt, I'm compliant. The responsibility is to actually do your due diligence, have the processes in place. It's not there to say that if someone does get injured, you're in breach. What will usually happen is if someone gets injured, there's a report to the regulator, to WorkSafe, and if they go into your business to determine that you actually just had taken no steps around health and safety, that's where the issues will arise, because we understand that, accidents happen, people are people, but if a business hasn't actually taken appropriate steps to prevent those happening, that's where liability can really accrue. And that also sort of flows into around, workplace harassment and discrimination, making sure that you have clear policies prohibiting, behavior like that, and a clear and transparent process for raising complaints. It's really important, from that forms part of your holistic, I guess, workplace health and safety. It's not just physical risks, it's also those psychosocial, psychological risks as well. So, you might be sitting there going, I'm in an office environment, there's still risks and steps that you might need to take as well. It's not just for high risk industries like manufacturing, construction, forestry, things like that. And that's where things like your employee handbook can actually be really useful. So setting up minimum responsibilities and minimum expectations around dress code, what your disciplinary procedures look like, what your leave processes look like, and any discretionary policies you might have about leave. Some people offer extra annual leave entitlements, and they might want to kind of set that up clearly so that there's transparency on both sides as to what those are. And then sort of the last point I'll make is around understanding the distinction between employees and contractors. There's a few tests set out in the legislation around, maybe how integrated the contractor is, and, how involved or how separated they are from the business, or how much control you have over them. It's always a contentious point. There's always a lot of, I guess, discussion and sort of debate, not only at sort of, industry level, but also at government and at legislative levels around how do we draw a clean line between who is an employee and who is a contractor, obviously trying to balance, individual, or I guess risk to individuals from being, mistreated or being misclassified as a contractor, but also, giving employers and businesses certainty as to, what basis they're engaging someone on. So actually just recently, there's been an amendment proposed to the Employment Relations Act to add in, I guess, a 4 criteria test that would determine, I guess, if these 4 criteria are met, then the person is a contractor. If the test isn't met, then this kind of existing rules around control and integration will apply. So that 4 criteria test is, the first is there a written agreement with the worker that says that they're an independent contractor? So that's obviously pretty easy to meet. The second requirement is that, the business can't restrict the worker from working for another business, including competitors. So you can't have any restraint of trade, non-compete. That'd be quite common for, think of your plumber. You're not going to tell your plumber that they can't work for anyone else. They're a contractor. They have a business to run. The third requirement is that you're not requiring the worker to be available on specific times or days or for a minimum number of hours, or they have the ability to subcontract the work. So, if you think about an employee, you've asked them to show up 9 to 5 days a week, and you want them to do the work. Whereas a plumber, to use that example again, they'll tell you when they're kind of free, or you might have an expectation of what sort of services you require. But ultimately, they might send one of their other employees to do the work. So that's more of a pure contracting arrangement. And then the last requirement is that the business doesn't have the right or doesn't terminate the contract if that contractor doesn't accept an additional task. So again, to use the plumber example, you're getting your kitchen sink fixed and you say, hey, while you're here, can you please also fix the shower under the same price? They have the right to say, no, that's a new quote, or no, I can come back in a week. And whereas in employment, it's a bit of a different setting where if your employer asks your employee to do something, there's an expectation that it forms part of your role and that you'll perform that additional task where reasonable. So that's just something to keep in mind. Not the law yet, but it's just been introduced. So that will be an interesting one to watch to see how it progresses. So I'm going to pass back to Tayler now just for our final topic on data protection and privacy, which is obviously becoming increasingly important.
Thanks, Stephen. So the key piece of legislation here is the Privacy Act 2020. So this act introduces new privacy breach notification requirements and gives the Privacy Commissioner greater powers. So as a general overview, the act ensures that individuals know when the information is being collected, that this information is used and shared appropriately, that this information is kept safe and secure, and that individuals can get access to the information. So what does the Act require? In terms of what you must do, you must only collect the information you need for a directly related business purpose. You must tell people how, when, and why you are collecting the information, and this includes when using things like cookies on your website. You must tell people what will happen if they don't give you their personal information, for example, if that will impact your provision of your goods or services. And you must keep the personal information of individuals safe and secure. You must also only use the personal information if you are reasonably sure it is accurate and up to date, and let people see their information and correct any mistakes if needed. In terms of what you must not do, you must not ask for any more information than you need. You must not let information be leaked, hacked, or found in any other way. You must not keep information longer than you need it, or longer than you are legally required to keep it. And you must not pass on someone's details without their permission. This is why it's so helpful to have, or so necessary to have a privacy policy that outlines what personal information you collect, how you use this information, who you share it with, and how individuals can access and correct their information. So I'll now pass over to Stephen to wrap up the section of the webinar.
Thanks, Tayler. So yeah, that concludes the main part of the webinar for today. I'll give you some time to just put some questions in the Q&A box if you have any. We do have a bunch of pre-submitted questions to get through as well, so we'll see how we go for time. We do have this publication, which is our New Zealand Startup Manual. You might find it useful. It just has a lot of general information about starting a business and also information for existing businesses that you might find insightful. So you can I think that will be sent to you, or you can use the QR code on the screen to download that. So I'll just give you a second if you're doing that now. You might also find our upcoming event quite useful. So it's on resolving director strategies for, small business owners. That'll be with Jody, who's a practice leader in our disputes team, and with Anina, who is a senior associate in our corporate team. So really, really great lawyers and have a lot of information and insights for you there. While we're just sort of waiting for some questions to come in, we'll take a minute to tell you about our membership offer. So LegalVision is quite unique in that it offers a membership service for businesses. As part of our membership, you'll get unlimited access to our full team of over 100 specialist lawyers for all your business's usual legal needs. So it's essentially like having your own in-house counsel, but obviously for the fraction of the cost. Things that the team will be able to assist you with are things like unlimited document drafting and reviewing of your business contracts, unlimited legal advice consultations, and then unlimited domestic trademark registrations and much more. So essentially, you don't really have to worry about, I guess, fixed fee hourly rate costs for most of your business's usual legal needs. It's basically like having your own in-house lawyer. We'll take care of business's usual work so you can focus on actually running your business. And we also offer a dedicated service for in-house lawyers and general counsel to actually manage their kind of high volume legal work so that they can focus on the more strategic or operational tasks that they often get pulled into. If you're interested in the membership or you're an in-house lawyer and you want to find out more about our kind of enterprise or in-house solution, I really recommend that you take advantage of the complimentary consultation, which I think a link will be sent to you anyway, but there'll be a slide at the end I think you can use to sign up. Perfect. Okay, so we will now ask some of your questions, and I'm just looking through some of the questions we've got here. I think, Taylor, this is a good one for you.
Mm-hmm.
So what are some advice on how small business should market their services?
Sure. So you definitely could consider marketing online or on your website and in your social media advertising. The most important thing to do is to ensure compliance with the Fair Trading Act. So to do that, you always need to be truthful and accurate in your advertising. Before making any claims, ensure you have evidence to support them, and that can be evidence that you've generated internally or information that you're relying from your supplier, for example. You just need to be particularly careful, as we flagged, with country of origin statements and sustainability claims. So in general, just avoid using vague or exaggerated statements that could mislead consumers, and just regularly review your advertising materials, including your website content and your social media posts.
Perfect.
Stephen, I'll think this one will be a good one for you. How do I go about restructuring from a sole trader to a company?
Yeah, I mean, it's a really good question and one that comes up a lot, especially for, I think a lot of the time when you might have started with a sort of a side hustle that kind of blows out into a full-on sort of full-time commitment overnight. I think the key things are, obviously you've got to set up the company. So that's the first decision is, what structure will that look like? Are you going to have multiple companies? You're going to have one for your IP and one for your operational day-to-day. And then once you've kind of made that decision, and usually there's a bit of, I guess, a tax assessment that goes into that as well around what might be the most tax effective structure for that kind of company group. Then there's the actual legwork of just transferring all of that risk and responsibility to that new company. Now, if you've got employees, there's this very specific process around transferring them. I think it's called like a technical redundancy, and you need to get that correct. So there's kind of a prescribed process for making that transfer. Transferring IP is I think relatively easy when you know what you're dealing with, especially in New Zealand where there's no capital gains tax. It kind of makes the whole process a lot more straightforward. In other jurisdictions, or if you have businesses in other jurisdictions, there can be capital gains events that take place when you do transfer, an asset like IP from one entity to another. And then there's actually your customer contracts or supplier contracts, and we find that those are typically the more difficult ones. In a perfect world, there'd be a contract called like a novation deed, and that would essentially substitute out the sole trader for the company. But in some cases, that's not always feasible, and then we kind of need to, I guess, transfer them in a way and kind of, I guess, have the company agree to protect the sole trader if there is any lingering or historical risk. But that kind of depends on who you're dealing with and what sophistication your customers are. And, oftentimes if you're dealing with customers on a one-off basis, there's not actually a need to transfer contracts. But if you have a written agreement, that's where that process kind of comes into play. We're getting a lot of questions in. Tayler, here's one for you. So what do I do if I think a privacy breach has occurred?
Mm-hmm. So the first thing to do is to take action to contain the breach and just prevent any further unauthorized access. So you definitely want to kind of limit the amount of data that's being exposed. And then you should evaluate the nature and extent of the breach, including what personal information is involved and who might be affected. So just trying to understand the scope of the breach and, as I said, who's been impacted. The Privacy Commissioner's website has a helpful feature called Notify Us, which has a number of questions which help you determine if you need to notify both the Privacy Commissioner of the breach as well as the affected individuals. So sometimes you'll need to inform people that their data has been exposed, and other times it's not necessary. So that tool is quite helpful. You'll then need to investigate the cause and obviously take further action to prevent future breaches. And throughout this whole process, you should really document and keep a record of what the breach was, the cause, and your response to it, and how you've taken action to mitigate that in future, just so you have that to refer to ongoing.
Oh.
Right.
There's a similar, there's actually, I was going to say there's a similar question, how on reducing the risk of experience a serious data breach and breaking the law. So Tayler, I guess Taylor's touched on the after it's happened type stuff. In terms of the stuff that comes prior, obviously there's all your technical safeguards, having a clear cybersecurity protocols, passwords, security, admin rights and things like that, kind of all the internal things that you can take, steps you can take, not leaving your laptop open in a public cafe and walking away from it, things like that. But in terms of the actual what the regulation sets out, there's kind of three main things that I think are the most important. So one is only collect what you need. So the Privacy Act sets out a number of privacy principles, and Tayler sort of actually walked through them in the slides on privacy at a high level. The key in the first privacy principle is only collect what you need, and it's called the principle of data minimization. So it's not about, or a business shouldn't go about things thinking, I need to collect all this information just in case I need it in future. So the first step is really just being really diligent and really clear on what you need and why. It's quite common to see, we've seen collection forms where a client's like, oh, this is my standard intake form, and it's asking for a whole bunch of irrelevant information that doesn't actually make sense. Imagine asking for, you sign up. I'll use the plumber example again. Your plumber sends you a new client form, and it's got on their marital status. Like what relevance does that have to whether your kitchen sink's clogged or not? Stuff like that. And then I guess related to that, once you've kind of determined what you actually do need to collect, not holding on to it longer than necessary. So a really good example, and the reason for that is because the more you hold, the more risk of things getting out there and the more risk of serious harm occurring. So a really good example, not in New Zealand, but in Australia, is the few data breaches that have happened there that were on the news. So Medibank and Optus, and I think Optus being the good example here. So when Optus had an unauthorized kind of access into their system and data was stolen, a lot of the people impacted weren't actually active customers of Optus. And in some cases, they hadn't been customers of Optus for maybe 10, 15 years, which begs the question of why Optus felt like it needed to hold on to all of that data when there hadn't been a business relationship with those individuals for over a decade. And it's things like that I often say to clients. It's, why do you need that information? Maybe it's look, I can understand there are times where you might need it for, if you're in an industry where you think there might be a risk of legal proceedings and you need to have kind of a file note or a record, things like that. There's obviously there are periods, statute of limitations where after a certain time a claim can't be brought anyway, and depending on the type of document, you should have a policy in place that sets out how long you hold things for. But if you no longer have a business relationship with someone, it's probably a good thing to go through and go, well, do I need a copy of their passport, or do I need X, or do I need that? Like maybe I just need to know that they were a customer, and what maybe their phone number is in case there's ever an issue, but actually, maybe I don't even need that. So it's just about being really diligent on why you're holding to something and not just holding on to it because you might need it if they become a customer again, because if they do become a customer again, you should just collect all that information fresh, because you do have that responsibility to make sure that what you hold and use is accurate and is up to date. And then the last thing I would say is it's actually around having clear internal processes around privacy compliance. So things like a compliance manual, a data breach response plan, a documented data retention policy are really important, because what the regulator will look at is it kind of recognizes that you don't often have sometimes control over someone hacking into your system, right? You might have been, obviously there are situations where you might be negligent, you might have not put any cybersecurity steps in place. But there are also times where you've actually done everything you can. You've had all the internal processes, all the security controls, and something still just takes place. It still goes wrong. And so what the regulator will go through is they'll actually look at all those things and say, well, if you've taken all steps and you've taken steps to kind of mitigate any serious harm that's taken place, then that will be, you might actually have a defense or a kind of not a get out of jail free card, but like it'll be taken into consideration and may actually just resolve the risk of there being any sort of compliance notices or fines issued against you. So that's just something to keep in mind as well. Anyway, that's enough on data privacy. Tayler, one for you. So what if someone leaves a negative review on the website? We talked about, dealing with, online reviews and things that you should do and be honest in your dealings, but we do get a lot of requests from people. So I can understand why this has come through around someone has left negative review. What can I do about it?
Yeah. So as flagged earlier, you're not able to delete or kind of hide any of those negative reviews. So the best approach is to acknowledge the review and respond to it politely, publicly, and ask to resolve the issue privately, such as via email. So if you can fix the issue and rectify the customer experience, then there's a potential that the customer will delete the negative review, or alternatively, for any new kind of potential customers reading your reviews, they'll obviously see that you're acknowledging the issue and acting to resolve that, which is reassuring and helpful, and will go a long way.
Oh, there's one here around which business structure is best for overseas expansion or seeking investment from third parties. I touched on this earlier, so I'll keep it brief, but it's most likely a company. Companies are much more flexible and much more widely understood in other jurisdictions. Things like partnerships can be a bit hard for other jurisdictions where maybe they don't exist or they're dealt with in a different way to kind of comprehend. It also means, like I said, when you've got a company, you've got shares, you can sell those shares, raise capital, bring on further investment, things like that. So having a company just gives you much more flexibility from that perspective. There's another question here, actually, Tayler, and maybe we can take this one, see how much time we have to squeeze in another one, around clauses and contracts and unfair contract terms. This isn't actually something we touched on in terms of the consumer law, but obviously very relevant and comes up. So the question here is, what sort of, are there any examples of clauses that are considered unfair or that we should avoid using? Maybe shed some light on that.
Absolutely. And there certainly are. It's difficult to give kind of a blank answer as to what clauses you should avoid, but there are clauses which are considered unfair contract terms and are therefore unenforceable. And those are generally clauses which cause a significant imbalance between the parties' rights and obligations. Or if a clause is unnecessary to kind of legitimately protect a party's interests, or would cause significant detriment to a party if relied on. So a common example of that would be cancellation fee clauses. So if you're a service provider, you may want to recover some sort of fee if somebody cancels kind of without sufficient notice, but it's really important that any fees that you're charging are an accurate reflection of any loss of profit that you've encountered. So for example, if somebody kind of cancels with 2 weeks notice, it's likely that sufficient amount of time for you to be able to secure another booking and replace that loss of profit. So that would potentially be more unfair. Whereas if somebody cancels with 24 hours notice, it would be more legitimate to be able to kind of enforce that cancellation fee. So it does kind of differ on a case-by-case basis, depending on the services that you're providing or the goods that you're selling, and the amount of detriment that it'll cause the consumer if relied on.
Yeah, definitely. And another one we see as well is long like auto renewal or lock-in contracts. Similar thing where a contract might have like a 12-month period and then it kind of silently renews for another 12 months and there's no right for the consumer to kind of or for the other party to actually exit, or they're not reminded that the contract's renewing, things like that that are kind of easy to catch people out. So that's one thing to keep in mind. And another one that's kind of just come up recently in the New Zealand context, although it didn't kind of progress much further, was around Viagogo, the ticket reseller. There was sort of I guess, commentary from the court recently where their governing law clause, which sort of set out where disputes had to be heard, in their contract, I think their terms and conditions with New Zealand customers said that all disputes had to be heard in Switzerland. And then obviously the New Zealand court rejected that and said that, trying to require a general, person off the street, an everyday consumer, to exercise legal rights in Switzerland is inherently unfair. So there are sort of obvious ones where it's maybe one-sided, your liability is excluded, or you're trying to push all this liability onto your customer, but all really they need to do is make payment. Things like that where, sometimes it just doesn't make sense. So there's lots of resources online too, especially in Australia. There's been I'd say a larger focus on unfair contract terms, and the penalties there are sort of in the millions. So the amount of resources, I'd say, are quite useful in the Australian context and translate quite well to New Zealand. I've just noticed the time. Unfortunately, we've had a lot of questions today, and so we haven't been able to get through them all. So sorry if we haven't been able to get to yours. If we haven't got to your question, I really recommend you claim your complimentary consultation. So you've got 48 hours to do that. If you want to claim it, just leave your contact details in the survey at the end of the webinar. But otherwise, we value your feedback. Really recommend you complete that survey as well. And thanks for joining us. Keep an eye out for future webinars from us, and obviously that one on the 24th of September around the directors' obligations.